Hello, friends. If you hold your dwelling and you are beyond 60, there exist 5 crucial documents that control what happens to everything you have built: your home, your savings, your medical choices, your desires the instant something unexpected occurs. And according to a major nationwide study released just 6 weeks ago, in June 2026, 56% of Americans have none of these. Not one document. 56%. Today, I am examining all 5, what each one does, what happens to your family without it, and exactly how to get it established. Before we start, if you are 60 or older, already retired or approaching retirement, and you have ever felt like the Social Security and Medicare system was designed to confuse you intentionally, I created something specifically for you. It is called the American Retirees Money Playbook. Every rule, every form, every phone number, all verified against the 2026 government data and written in simple English. People who have used it have discovered Medicare overcharges, found Social Security money they were owed for years, and stopped paying taxes on benefits they never should have been taxed on in the first place. If any of that sounds familiar, the link is in the description and the pinned comment. Scan the QR code if you are watching on TV. Now, let us get started. Document number 1, the one that protects your finances if you ever cannot speak for yourself, and that only 11% of Americans currently have in place. A durable power of attorney, also called a financial POA, is a legal document that designates a person of your choice to manage your financial affairs if you become incapacitated. Pay your bills, access your bank accounts, file your taxes, manage your investments, sell your home if necessary. Without this document, none of those things can happen. Not by your spouse, not by your adult children, not by anyone until a court appoints a guardian or conservator to act on your behalf. Here is what that process looks like in practice. You have a stroke. You are in the hospital. Your spouse wants to access the joint savings account to pay the mortgage. The bank will not release funds from an account that is partly in your name without your signature or a legal authorization. Your spouse goes to court, they hire an attorney. The process takes anywhere from several weeks to several months depending on your state and the court's schedule. Legal costs typically run between $3,000 and $10,000. And during that time, while the house payment is due, while the utility bills are accumulating, while the medical bills are arriving, nothing can move. A durable power of attorney, signed before any of that happens, costs between $100 and $300 to have prepared by an estate planning attorney. It designates your chosen person, defines their authority, and becomes effective the moment you sign it or the moment you become incapacitated, depending on how it is structured. Durable specifically means it remains valid even if you lose mental capacity. A standard power of attorney becomes void if you become incapacitated, which defeats the purpose. Make sure the document specifically uses the word durable. Document number 2, the document that decides who makes your medical decisions and what those decisions will be. An advanced healthcare directive combines 2 related documents: a healthcare proxy, also called a medical power of attorney or healthcare power of attorney, depending on your state, and a living will. Only 19% of Americans have these in place. According to the 2026 Trust and Will National Survey, the healthcare proxy designates a person to make medical decisions on your behalf if you cannot communicate. Without it, hospitals default to next of kin, which sounds fine until you consider that next of kin may mean a family member you would not have chosen, or that multiple family members disagree about what you would have wanted, creating conflict at the worst possible moment. Courts have had to intervene in end-of-life situations, specifically because no healthcare proxy existed and family members could not reach agreement. Naming your own person eliminates that possibility. The living will is the companion document that tells your healthcare proxy and your doctors what you actually want. Do you want aggressive life-sustaining treatment in all circumstances? Do you have conditions under which you would not want resuscitation? Do you have preferences about where you want to spend your final days? At home, in a facility, in hospice? These are deeply personal questions that most people do not want to think about. But the alternative is that someone else answers them for you under time pressure without knowing your wishes. In most states, advance directive forms are available for free from your state health department or from a nonprofit like 5 Wishes. You do not necessarily need an attorney to complete them, though having an attorney review them ensures they are valid in your state. What you do need is to sign them in front of witnesses and in most states to have them notarized. Document number 3. The document most people think they have handled and have not. Among homeowners, 40% have a will, which is more than double the 16% rate among renters. Homeowners are more likely to have a will than any other group, and yet 60% of homeowners still do not have one. And for the 40% who do, there is a critically important follow-up step that most of them have skipped. A will tells a court how to distribute your estate. It must go through probate, a legal process that in most states takes 12 to 24 months and costs between $10,000 and $15,000 in legal fees, calculated as a percentage of the gross estate in many states. During that period, your family cannot sell your home, cannot access assets titled in your name alone, and cannot complete any financial transactions involving your estate. But here is the thing that most videos about wills do not tell you. Your will does not control your retirement accounts, your life insurance, or any account with a named beneficiary. Those assets transfer directly to whoever is named on the beneficiary designation form, regardless of what your will says. A Supreme Court ruling, Eglahoff versus Eglahoff, confirmed this directly. The beneficiary designation controls even when it contradicts a divorce settlement or a court order. If your ex-spouse is still named as beneficiary on an IRA you opened 20 years ago, your ex-spouse receives that money. Your will cannot override it. Take the action. Log into every retirement account, life insurance policy, and bank account you own and verify who is named as beneficiary. Update any outdated designations immediately. Do it this week, not when you think of it again. Document number 4, the one that determines whether your home goes to your family or to a probate court. Your home is almost certainly your most valuable asset, and without a specific legal mechanism in place, it goes through probate when you die, regardless of whether you have a will. A will does not bypass probate for real estate. It tells the probate court what to do with your home. The court then conducts a process that costs money, takes time, and is public record. There are 2 primary ways to transfer your home outside of probate. The first is a transfer on death deed available in more than 30 states as of 2026. A TOD deed lets you name a beneficiary directly on the deed. You retain full ownership and control while you are alive. You can revoke it, modify it, or sell the property at any time without the beneficiary's involvement. When you pass away, your beneficiary records the death certificate with the county and the property transfers automatically. No probate, no court, no waiting period. Recording a TOD deed typically costs $20 to $50 at the county recorder's office. The second option is a living trust, also called a revocable trust. You transfer your home and other assets into the trust during your lifetime. You remain the trustee, meaning you control everything while you are alive. When you pass away, the successor trustee you named takes over and distributes assets according to the trust terms without probate, without court involvement, and without the process being public record. A living trust costs between $1,000 and $3,000 to establish through an estate planning attorney, but can save tens of thousands in probate costs and months of delays. If your state offers a TOD deed and your primary goal is keeping your home out of probate, the TOD deed is the simpler and less expensive solution. If your estate is more complex, multiple properties, blended family, business interests, a living trust typically provides better control and flexibility. Document number 5. The free document that 90% of seniors do not have and that their families desperately need the moment a health crisis hits. A HIPAA Authorization is a 1-page form that allows the people you designate to receive your protected health information from your doctors, hospitals, and insurance companies. Only 10% of Americans have one in place according to the 2026 Trust and Will Survey. Without it, doctors may defer to next of kin or require court intervention. More specifically, without a signed HIPAA authorization, your adult children cannot call your doctor and get information about your condition, your diagnosis, or your treatment plan, even in an emergency. The hospital cannot discuss your case with them. They sit in the waiting room, knowing nothing while you are in treatment, unable to advocate for you, unable to ask questions, unable to coordinate your care because the law prohibits your medical team from discussing your case without your explicit written authorization. The HIPAA authorization form is free in most states. It is available from your doctor's office, your hospital, or through your state health department. You fill it out, designate who can receive your health information, sign it, and give a copy to your doctor, your hospital, and the people you have designated. It does not require an attorney. It does not require notarization in most states. It takes about 10 minutes, and the moment a health crisis happens, it is the difference between your family being informed partners in your care and strangers waiting in a hallway. So, here is your complete checklist. A durable power of attorney, not a standard POA. Specifically durable. Designates who manages your finances if you cannot. A healthcare proxy and living will. Designate who makes your medical decisions and document what those decisions should be. A current updated will and critically updated beneficiary designations on every retirement account, life insurance policy, and bank account. A transfer on death deed or living trust that keeps your home and other assets out of probate, and a HIPAA authorization that allows your family to receive your medical information when they need it most. The gap between people who believe they need a plan and people who have one is the central story of estate planning in America in 2026. 73% of Americans say estate planning is personally important. 56% have none of the 5 documents. If you are watching this and you are in that 56%, the time to fix it is not when something happens. It is now, while you can make these choices yourself, calmly, and on your own terms. Subscribe. Share this with every homeowner you know who is over 60.